Okay, yesterday and today was Eric Lewis, who's an American lawyer, and he spoke about 5 areas. One was sentencing, how they arrange their sentences and how it got to 175 years estimate. The other was jail conditions, what are the conditions in jail, in particular in Supermax prisons, ADX. They described that the conditions in jails were parlous and very, very difficult. The frequency of mental illness and suicide was great. Then the argument that was surrendered to around First Amendment conditions. The First Amendment is free speech, and this is very important in the United States. So the prosecutor argued that it didn't contravene the First Amendment and didn't endanger First Amendment into the future, whereas the defence demonstrated clearly that the entire indictment would actually allow somebody to be arrested for reading the paper. Health treatment, it was the next thing, the mental health treatment, which is shocking in their jails. And finally, the changing approach. So the Obama administration decided not to prosecute Julian and let the case fall. And upon the Trump administration coming in 2016, in 2017, in April, Mike Pompeo resurrected the case while he was head of the CIA. This afternoon it was Thomas Durkin, he's an American lawyer from Chicago, and he covered the area of penalties and plea bargaining cooperation. So they give you 175 years, but say if you give up all the names of the WikiLeaks staff and sources, then you'll only get 100 years or whatever absurdity they propose. The nomination of sources is a controversial problem for journalists. You never nominate your sources, you always protect them. Then the changing approach of the political consideration was canvassed again, and that lawyer said that it was clear to him, he had worked in the Department of Justice for 6 years, that the Obama administration had decided not to prosecute, and it was the political decision that A.G. Barr and the Trump administration that decided to prosecute this case as it is now. That also they spoke about the defense. Now, in the national security cases, the defense lawyers can go into a room with a computer that is read-only. They can read the classified information, but they're not allowed to discuss the classified information with the defense, with the accused. This is a court, so most cases where there's a national security case, that turn up a guilty plea. I think there's only 6 that haven't. But overall, there's never been a case in the United States where a publisher has been prosecuted for publishing national security items. Never been a case. This is the first one. Thanks. See you tomorrow.
Thank you.
Thank you.